Hello everyone, and welcome to this week's Wednesday webinar. Burkitt Long is offering a series of weekly webinars on a range of different subjects for individuals, families and businesses. I am David Rayner, a commercial real estate partner at Burkitt Long, and I'll be joined by my colleague Emma Jenkins, who is a property dispute resolution specialist, in a minute or two. This week, we're looking at rent repairs and other concerns for business tenants during lockdown. We will take questions at the end, so please do make use of the Q&A facility. And if we move on to the next slide, just to let you all know that what we're saying, the information is correct as at the 7th of May. And obviously things are moving very quickly at the moment. You'll all know that from the announcements that we've had this week. So please do come back to us if you need any further advice, or if you think you may be affected by any changes that come in after today. The topics that we're going to be covering today are firstly the financial difficulties and rent obligations on tenants, looking at the 2020 Coronavirus Act, other landlord remedies, thinking what else tenants can do and what happens if the landlord goes bust. We're then going to consider repairs and dilapidations. Then we'll have a look at practical considerations. Can you end the lease? What other aspects are important? Insurance, provisions and other tenant obligations in the lease. And then I'm going to have a look at cost savings, greening your business, because as many of you will know, I'm not only a commercial real estate lawyer, I lead our environment and energy group. And we'll then round up with conclusions and then have our questions. So I'm now going to hand over to Emma Jenkins.
Hi everyone, thanks for joining us today. As David said, my remit of specialism is property litigation, both on the commercial aspects and the residential. Today I'll primarily be talking about the recent changes affecting all commercial tenancies, and then David will be giving you a steer, as he said, on the more practical solutions and things you can be doing to help yourselves during this time. The Prime Minister's speech originally came out on the 23rd of March, mentioning the current lockdown, and this has been far reaching on everybody, not to mention commercial tenants. It's important to remember, and I will say this as a caveat, that all leases are individual, and as such, whilst this talk is aimed to provide general guidance as to what the current regulations are and how perhaps to approach situations, it doesn't substitute getting specific advice on your lease. So I think that warning does need to be given. Okay, so the starting point, we're looking at the current legislation in place, is of course the Coronavirus Act 2020, which I'm sure you will have all heard of. This received royal assent on the 25th of March this year, and any references to the Act throughout this presentation should be taken to the Coronavirus Act 2020. The Act applies to all commercial tenants in England, Wales and Northern Ireland, and currently provides for a period of protection until the 30th of June 2020. There is an option for the government to extend this should they feel necessary, although to date we haven't had an indication as to whether this will be extended or otherwise. So for the basis of this speech, we're working on the current deadline, which is the 30th of June. The key measures introduced to protect commercial tenants are under Section 82 of the Act. And these provide that during the relevant period, so until the end of June 2020, commercial landlords are unable to forfeit a lease due to the non-payment of rent by their tenants, whether this be by re-entry, so peacefully re-entering the property, or by issuing forfeiture proceedings. Section 82 also provides that for any forfeiture claims which were issued before the Act came into force, tenants cannot be ordered by the court to give up possession before the end of the relevant period, so before the end of June. When we look at a landlord's inability to forfeit a lease, it's purely down to rent. Rent is defined in the Act as any sum which the tenant is liable to pay under the lease. So this includes service charges and insurance rent contributions, as well as what many people typically define as their monthly rent. The moratorium, so the suspension, will apply to all business tenants as defined in Part 2 of the Landlord and Tenant Act. So we'll cover all business tenancies. It's important to note and remember, however, that these protections will not apply to those occupying premises by way of a tenancy at will or any other contractual arrangement that doesn't provide for exclusive possession, or short leases of 6 months or less. There are some exceptions to that, but generally speaking, if you've got a short lease, you need to be really careful. So the practical implications introduced by the Act mean that tenants have been afforded a small window of breathing space, but it's really important to bear in mind some key points. Number one, that during the moratorium, tenants remain liable for their rent, so it doesn't waive the liability to pay that rent, it essentially just pauses it. Without any further developments, landlords will still have a right to forfeit a lease and recover any arrears that have occurred since the introduction of protection from the 1st of July onwards. So this will leave tenants potentially exposed at the end of the moratorium if no further protection is introduced by the government. You may query whether a landlord would want to forfeit a lease in light of the current climate, although it's really important to bear in mind that this risk is there, and as such, any amicable means or any discussions with your landlord will remain crucial. So the Act deals with non-payment of rent and forfeiture, which is obviously the key protection the government felt necessary to protect commercial tenants. The issues that many commercial tenants will still face, however, is, well, OK, my landlord can't forfeit my lease, but what about the other methods of enforcement, the other methods that previously a landlord would have been able to access if the tenant didn't pay the rent? So I will briefly touch on these. This isn't a comprehensive rundown of every single method of enforcement. It's simply an overview so that tenants, albeit with the protection of the Act, can keep these in mind. So rent deposit deeds, these will be specific on each of the premises, but typically they've been used by landlords to deduct from if a tenant fails to fulfil its responsibilities. So generally speaking, if a rent payment is not met, they can be deducted from the rent deposit and then the tenant's required to top those up. The Act doesn't impact on rent deposit deeds. So whilst, again, it's really important to check the term-specific rent deposit deeds, the landlord is technically able to deduct from that and then require a tenant to top up. Query again whether they will or not, because if a tenant can't top that up, that's then a pot of money essentially that's gone should the tenant default again, but the option does remain there. A landlord can also issue standard debt recovery proceedings for any outstanding rent. This hasn't been altered by the Act at the moment, so it does remain open for a landlord to issue a monetary claim to recover outstanding rent. Again, one would query if advising a landlord whether that would be an attractive option. The courts are struggling somewhat with the current changes, as you can imagine. Technology isn't quite up to the standard that would allow maximum efficiency in the courts, and equally obtaining a judgment against a tenant that may have limited assets at the moment or struggle to pay could be spending good money where actually an amicable solution could be reached. So tenants may feel a little bit relieved by that, but again, it's worth bearing in mind that that option is there. Guarantor claims, your landlord can still seek to enforce any action against a guarantor. Whether they will or not is an unknown, but as a tenant, just keep that in mind, that if you do have a guarantor for your lease, the landlord can still, irrespective of the Act, rely on that. Now, there's two further methods of recovery which I suspect will be a greater concern to commercial tenants, and there's been an awful lot in the press recently about each of these. The position in respect of each of them is very, very unclear. Unfortunately, both of these methods of enforcement I'll speak about in a minute have had a government announcement that they will be introduced to help tenants, although the actual legislation to implement that is yet to be fully implemented. So it's a really uncertain period, but I think the message to take from it is that the government had made an announcement that these measures are being put into place, and as such, that should offer commercial tenants some comfort in the sense that it gives a really strong indication as to what the government expects and in turn what approach the court are likely to take to these. So the first one is commercial rent arrears recovery. Many of you will be aware of this, but essentially it allows the landlord to enter into a rented premises and seize assets up to the value of any outstanding sums. The intricacies of it are outside the scope of this, but the key message is that the government has or is enacting secondary legislation to prevent a landlord from using this method of enforcement until 90 days more or rent is owed. So they can't simply say you haven't paid a month's worth of rent. You have to have your 90 days more or more unpaid to use this method of enforcement. Now, this protection was announced in the government's plans at the end of April, so the 23rd of April. The secondary legislation, as at the date of writing this presentation, hasn't appeared formally, but the government have said that those restrictions are being put in place. Again, it's not perhaps as secure a guarantee as a tenant would hope to have, but one would have to query the commercial sense in any landlord perhaps pursuing this, because naturally by taking away the assets that a company relies on to function, you wonder whether that will in turn then damage the company to an extent that they'll be even less able to pay the sums due to the landlord. So not a particularly attractive method for a landlord in the current climate, but the government are putting or attempting to put into place assistance for commercial tenants to mean that this aggressive form of debt recovery that it's always been seen as is limited in its impact. Now, the other form of enforcement that the government have looked at and commented on relatively extensively is the service of statutory demands, and in turn issuing a winding up petition. So essentially the first steps of winding up a company due to a failure of its ability to meet its rental obligations. Now, the Corporate Insolvency and Governance Bill is in the process of introducing new measures, and again these are aimed to protect commercial tenants. Now, the key measures of most relevance for today's speech are any statutory demands and winding up petitions issued against commercial tenants where the company's inability to pay the debt owed is due to COVID-19 are to be temporarily voided. So I would imagine that there will be lots of cases whereby courts are determining whether the SAT demand and or the winding up petition have arisen purely as a result of the COVID-19 pandemic. I suspect that landlords will be arguing this isn't the case, and tenants will strongly be arguing, should the need arise, that it is. But that's the key. And again, it's the government's attempt to try and stop landlords using the aggressive debt collection methods whilst this pandemic's ongoing, and clearly commercial tenants are worried. The other key issue under the Corporate Insolvency and Governance Bill is that fresh statutory demands and winding up petitions will no longer be able to be issued to commercial tenants, again for those tenants who are unable to pay their debts due to the COVID-19 pandemic. So it's essentially the same prevention of those two methods of enforcement, but to apply to those already issued before the pandemic and those landlords that may wish to seek that method of enforcement at present. So again, promising that these measures are being brought in. There will be disputes as to why a company can't pay its debts, and as such the key will remain to try and amicably resolve any issues with your landlord. But there are those fallback provisions should the need arise. I think the key to take from this is that essentially there are the restrictions and the safeguards that the government are trying to put in place are well intended. There will be issues with all forms of restrictions put in by the government, and I think the key is that whilst it's important to be aware of the general position, should a landlord take any action, or you'd be concerned as a commercial tenant that they may be intimating, etc. I think the key is to get really swift advice. This area is changing on a day-by-day basis. We all know the message that the government are trying to send out. We all know that amicable discussions are encouraged, but where it's changing so fast, and obviously the severity, the implications, should enforcement action be taken, are great. The key will be to not only keep an open dialogue, but also to get in contact should any enforcement action be taken. So that's me on the unfortunate doom and gloom of the Coronavirus Act and the other methods of protection and potentially their shortcomings. But I think, as I say, the key to take from this is that that the government are sending out a very strong message to commercial landlords, essentially to give commercial tenants as much breathing space as they possibly can. So that's me, and now I'll hand you over to David to talk about the practical implications and perhaps what you can be doing to assist.
Thank you, Emma. Emma, they're taking you a quick run through of the legislation and the law. That's not because I don't know it, but as you can see, I'm far older than her, and I forget things more easily. I think actually practically we've seen a real range of different reactions to what's going on. Some landlords, as Emma has said, have undoubtedly been taking very aggressive rent collection steps. Some have been talking to their tenants and offering rent deferrals or rent reductions very early on to get it properly in place, probably to suit them and what they want, rather than it being forced upon them. And then at the other extreme, obviously, we've seen some tenants who you just feel are really trying it on. They could pay the rent, but they decide they don't want to at the moment, and are taking advantage of the government protections at the moment. So it's a bit of a mixed bag, but we'll try and talk you through some of the practical consequences. I think really if there's one message that you really must take away from today, that is that rent remains due under the government legislation. So you could get to the 30th of June, as Emma has said, and if the government doesn't extend the scheme or bring something else in, you could then find yourself with a landlord chasing you for 2 quarters rent and interest, and possibly the costs of any enforcement action that they take, and or trying to forfeit. Now, in reality, it's highly unlikely that a landlord is going to want to forfeit your lease unless he considers that you're an awkward tenant, or perhaps because he wants the property back to do something else with it, maybe to occupy for himself or to redevelop it, or he thinks he can get someone else in with a higher rent. It's unlikely in the current market, and I think most tenants will feel reasonably relaxed about what the landlord might do, but nevertheless there is an element of risk there that you need to be aware of. Overall, have to say, as Emma has said, the best solution by far is for the landlord and the tenant to talk together, make proper collaborative arrangements for sorting this out. As I said, there are a number of different ways of doing it. You could have a rent holiday, a rent reduction, a postponement or a deferral of payment, and other incentives as well. It really depends on what suits you best. Obviously, the rent deferral is very much what the current government proposals are, and that means that the rent still remains due, and you may well find yourself having to pay it later on, but that will be under a scheme for payments that you would agree with the landlord going forward. Rent reduction is obviously preferable from the tenant's perspective, so that, or a rent holiday, so that you have a definite period when you know you don't have to pay, or you're paying a reduced rent. And then how do you document it? Well, you could have a side letter, or you could do it as a deed of variation of the lease. For certainty, it's probably better to have the actual deed of variation. If you have a side letter, though, you must make sure that it binds your landlord's successors in case the landlord sells his interest in the property whilst this rent concession is going on, or perhaps, and I'll come on to it in a minute, the landlord goes bust, and then possibly what you've agreed wouldn't bind anyone that his receivers or liquidators or administrators try to pass the property on to. If you're having a deed of variation, then the landlord is almost certainly going to want to ensure that this is personal to you as his tenant and doesn't protect anyone else. The tenant getting into financial difficulties, and we know an awful lot are, but of course many are surviving at the moment. And I know, and I'm not just saying this because I know some of you are joining us for this webinar, but it's very important that if you find yourself getting into financial difficulty, you talk to an insolvency practitioner. The primary role of the insolvency industry is actually recovery rather than liquidation, and so see whether an insolvency practitioner can help you. You may want to think about a member's voluntary liquidation if the company is solvent, an administration, pre-pack administration, a creditor's voluntary arrangement to give you as the tenant some breathing space to sort out your arrangements. There is help out there for you if you find yourself getting into financial difficulties. What if your landlord goes bust? Well, it's unlikely to affect you as the tenant. The lease will remain valid, except in very rare circumstances, which I'm not going to bother potentially confusing you with now. But you might find that if the landlord has a liquidator, administrator, whoever, you might find that a new landlord is not as lenient or as accommodating as your previous landlord. So you just need to be aware that whatever you've agreed with your current landlord needs to be properly documented to make sure that it's going to bind successors in title. You do, of course, still have to pay your rent. And you do need to be aware, Emma mentioned rent deposits. You do need to be aware that actually, if the landlord goes bust, your rent deposit might disappear, and you may be called upon to pay because the new landlord doesn't have anything to draw on. The potential for a landlord's insolvency practitioner to disclaim that the lease on behalf of the landlord is, I think, going to be very, very rarely used, because it'd be very difficult to see that most rack rent leases are contrary to the landlord's best interests. So hopefully that's given you some practical commercial things to think about. And now back to Emma to go on to repair obligations and dilapidations.
Lovely, thank you, David. Okay, so this will be slightly briefer than my initial part of the talk, and the reason for this is because the Act doesn't impact on repair obligations. It only applies to rental obligations, which, as I said earlier, is any sums due under a lease. So the repair obligations, they essentially will remain unaffected, which I appreciate for many tenants will be slightly concerning, because a lot of surveyors, repairs, etc., handymen won't be coming out to premises. Now, the good news is obviously with the recent developments that will start to ease, and I suspect that the availability of workmen will become more and more improved. But that said, if a landlord does want to take action in respect of disrepair, etc., it's important to remember that just because of the pandemic, the position hasn't altered. So what will a landlord be likely doing? And many of you will be aware of this. If there is disrepair at the property and they become aware of it, if they want to bring an end to the lease, and again, so to forfeit it, they are able to do so, but they have to go through a series of steps. So by the service of the requisite notices and allowing the tenant the appropriate period to remedy and or reply, depending on the terms of the lease and the length of it. That remains in place, and clearly there will be landlords that will continue to try and take an aggressive, not an aggressive stance, but an enforcement stance. We want our property kept in the best repair and we're not content with this. And I think the key goes back to exactly what David has said. We need to be keeping an open dialogue with landlords and essentially being able to show that if that work can't be taken immediately, then all reasonable steps have been put in place to try and undertake it as soon as reasonably practical. That's a big thing that the courts would look at in forfeiture proceedings. So I think that that's the only key to take, keeping any evidence that you're responding, you're trying to be proactive with getting any repairs undertaken. Needless to say, if there are any landlords approaching in this respect, then a review of the lease would be necessary. So just keep a really clear eye on what your obligations may be under your lease. Secondly, I suppose this may well be for more concern to tenants nearing the end of their lease. Landlords at any time, but typically towards the end, will be serving a schedule of dilapidations potentially on their tenants. Now, the protocol that governs dilapidations, so any repairs that are needed at the end of a tenancy, provides that a tenant needs to try and respond to that within a reasonable time. So typically 56 days is what the protocol governs. That's not set in stone, but it's an example of what can typically be expected. If you are unable to meet that, e.g. you can't get a surveyor in, or as potentially a surveyor you can't attend a premises, then again it's just keeping that dialogue open. These are the arrangements we're putting in place, this is who we've contacted, this is what they've said, and the moment we're able to get a surveyor there or workmen to repair the premises, we will. Now, I need to say, if the term comes to the end, then the tenant's ability to enter the premises and undertake their works will have disappeared unless there's any other arrangement. But again, unfortunately, the Act doesn't provide for that. So I think the key to take away from this is that, notwithstanding COVID-19, the full repair obligations do remain in place. The legislation, the notices, the protocols, etc., governing disrepairs are all, as at present, unamended. So that the only thing that can be done is acting swiftly and keeping that dialogue open. That's all I've got on disrepair, David. So I'll hand back over to you.
Okay, so when we're looking at repairing obligations and then dilapidations liabilities in a lease, I think just very briefly to mention that, of course, there are different repairing obligations in many leases, different categories. So you may be required to keep a property in good and substantial repair, which is a tougher obligation than just having to keep it in tenantable repair. So you do need to look at your lease and see what you really need to do. That obviously leads on to the decorating obligations as well. Many leases provide that you have to decorate every 3 or every 5 years. If that's happening now, don't forget about it. And over all of these issues, as we've said already, make sure you're talking to your landlord so that they're aware that these things are not happening, or perhaps are happening in slightly more restricted circumstances, and that you will be going back, and once things get back to a more normal situation, you will then be sorting things out. It's very important to keep talking. On repair, just wonder whether that, or certainly with dilapidations, whether that will now include possibly an obligation on the tenant to carry out a deep clean as part of health and safety compliance, with obviously the COVID-19 concerns. Obviously, there's no cases on that at the moment. There's no that I'm aware of discussion about that at the moment, but it's just something to think about. If you're the tenant, might you have to do that at some point? The tenant's repairing obligations in leases always exclude damage by insured risks. So that brings me on to another important topic, which is insurance. I'm going to talk about that in a couple of minutes' time, but it is vital to make sure that the insurance is maintained, and it's also important for you as the tenant to make sure that you are maintaining, repairing the property, and that you are maintaining the security at the property to make sure that there is no damage either by insured risks or, worse still, by uninsured risks. Because if there is damage by something that hasn't been insured against, and it's usually the landlord who insures, then of course that's down to you as the tenant. And the last point I wanted to just raise here is the impact on disrepair on break rights. Many older leases, older break clauses will require compliance with the tenant covenants, and a requirement that if you exercise your break right, you hand the property back in the state of repair that is required by the lease. So if you haven't been doing that, there is a way there for the landlord to get out of having to accept you breaking the lease. So again, it's important to make sure that either you're complying, or at the very least you are talking to the landlord. He understands what you're doing, what you're not doing, and you are reaching an agreed position. And with that, over to Emma to have a look at some other practical considerations.
Lovely, thank you, David. Okay, so just a couple of things in terms of the broader picture. I'm sure many commercial tenants, this would have come as a really worrying time. That's entirely understandable. And I think an initial thought at some stage may have crossed your mind is, can I do anything to get out of this lease? Perhaps my business isn't profiting. Clearly this is unanticipated. What can I do, if anything, to try and bring my lease to an end? And unfortunately, whilst it's important to address that as part of this talk, the answer is not an awful lot. There are two key ways that may be open to a tenant to try and exit their lease. The first one is relatively rarely seen. It's a force majeure clause, which I'm sure many of you have heard of. And essentially, that's a clause that provides that either of the parties can be released from a contract in the event of an extraordinary event or circumstances beyond their control. So some may argue that actually the coronavirus is completely beyond their control, and as such should allow them to exit the lease. The issue we have here is that very, very few leases actually have these clauses in. So if your lease is one of the very rare ones that does have that clause in, then by all means seek advice on that specific clause and whether it can or cannot be exercised. But unfortunately, as I say, that's extremely rare in commercial leases. The other potential avenue open to commercial tenants is something called the Doctrine of Frustration. And that's where a tenant may potentially look to the doctrine if they're prevented from occupying their premises to get them out of the lease. This, however, to rely on that doctrine is an extremely high burden, as a contract will only be frustrated if an event occurs which renders it impossible to perform an obligation, or the obligation is radically different from when the contract was made. So whilst one may argue that actually we can't operate our shop, we can't operate our restaurant, whatever the business may be, there are no cases currently at the moment where a lease has been frustrated. So again, unfortunately, very unlikely to be of use to commercial tenants. That said, again, the situation should be kept under review in specific circumstances, such as where there is a very, very short term of the lease remaining. So again, case-specific advice would be needed on that. Two avenues for consideration, although both unlikely in the circumstances to assist, as the current state of play is. My next section will simply be concluding and sort of looking more to the future. So, David, I'll hand back to you for anything you may wish to discuss before we wrap up.
Okay, thanks, Emma. Practical considerations. And I'm not sure if we have many landlords joining us today, but obviously that from the landlord's perspective, you also need to think about if you've borrowed, perhaps to acquire the property, is anything that's happening now causing you to breach any of your banking covenants? So you may want to think about talking to your bank. Landlords are seeing significant rent hits. Landsec, who are one of the largest institutional landlords, for example, are predicting a 75% slide in retail rental income over the year. Very, very significant. So landlords are not having it easy by any circumstances, and indeed are talking to the government about a scheme to furlough properties whereby the tenant would pay some rent, the landlord would accept a reduced rent, and the government would fill in the gap in the middle. Those are very early discussions, and we wait to see the outcome of those. The other practical considerations for tenants, think about the insurance. Not only the insurance obligations under the lease, which, as I said, will usually be on the landlord. You need to make sure that the insurance obligations are not being breached. And for example, if an insurance renewal is coming up, make sure that the renewal is paid. What you don't want to happen is for the property to be uninsured. Could the landlord claim on rent arrears insurance? It's something to talk to them about. Does your, as a tenant, business interruption insurance cover the losses here? In almost the vast majority of circumstances it won't, but it's worth having a look just to check. And finally, on insurance, how is rent suspension triggered? Is it just physical damage to the property, or is it that the property has been made inaccessible? And if that is the case, have a chat to the insurers. They're initially going to say, oh no, it being inaccessible doesn't mean you can't get in because of COVID, but it's worth talking to them and seeing if there is anything that can be done there. If the property is vacant, and of course it is at the moment, make sure what the lease says about leaving property vacant, because many leases have a clause saying you can't leave it vacant for more than 2 weeks without putting appropriate security in place, telling the landlord. Again, as we've said time and time again in this webinar, make sure you're talking to the landlord, making them aware of what is happening. Security, is that the tenant's responsibility? If it is, make sure the premises are secure. Utility bills, make sure you're paying them. I doubt very much that on top of everything else you want to be cut off. Business rates, of course, if you're in the retail, hospitality and leisure sectors, you should be able to claim business rate relief. In fact, you don't actually have to claim it, that your local authority should be dealing with that automatically for you. And of course, there are other government business support schemes, loans that you ought to be investigating if you're a tenant and finding yourself in financial difficulty. Sorry. Finally, statutory requirements. I've already mentioned health and safety, but all other statutory compliance is down to the tenant. So again, make sure you're not letting breaches occur. And if they are happening, or perhaps as we're now being encouraged to go back to work, if you have to carry out works at the property to make them COVID safe, do those works need landlord's consent? I'm finding it difficult to think of any that would, but for example, if you have to put up partitioning, that might. So make sure that you're at least talking to your landlord about what you're going to do, and possibly, if the lease requires it, getting their consent for it. I'm now going to go on very briefly, as I said at the outset, and talk about some cost savings that hopefully may be of interest for you. Know these are difficult times, but tenants and indeed landlords will be trying to save costs wherever they can. And without being a tree hugger, the green agenda is something that can save you costs, make your finance directors very happy. If we move on to the next slide, look at your electricity use. How can you reduce it? Get LED lighting, get movement sensitive lighting, switch things off overnight, save electricity, save on other utilities as well where you can. Look at reducing your paper use. I mean, you won't be surprised to learn that Burkitt Long, being solicitors, we get through quite a lot of printing and paper use, but during the lockdown period we have seen enormous reductions in printing and therefore cost savings. So it's something that's worth looking at. Look at your other materials, your other raw materials, the other items that you use as part of your business. Can those be reduced? Can they be sourced ethically? And do you have members of staff who would like to be green champions? It always helps to have that amongst the staff, because it makes it easier. Why do it? Well, to save costs. It's increasingly relevant for your staff, for your customers and your business partners, and you will gain a commercial advantage. There is increasing regulatory compliance for it, and of course, in many cases, to do business with government, local government, big businesses, even smaller businesses now, you will be asked what your environmental plans are. We have to produce our sustainability plan quite often when we tender for work. So all of those reasons, as well as saving the planet. And then we're going to move on to conclusions, and I'll hand back to Emma so she can give her conclusions. Thank you.
Okay, thank you. Just to tie up then, obviously most of my discussion today has been on the recent developments in terms of the Act and the regulations. The great unknown and the great concern for commercial tenants will be what happens at the end of this moratorium. All we have heard from the government in various forms has been 30th of June, 30th of June. That is a grey area that no one knows the answer to. You would hope and you would consider that actually lifting every single restriction come the 30th of June would be counterproductive to everything that's been put in place to date. The logic that a company that perhaps couldn't pay its quarter rent at the end of March will now be able to suddenly make payment for 2 quarters is flawed and improbable. So one would imagine and anticipate that those protections will be extended whilst the economy gets back to something near normal, although of course there's no guarantee. Now, there has been some relatively heavy resistance to that inevitably by landlords' bodies, so it will just be a case of watching this space and keeping an eye on what government measures are introduced and whether these are extended or not. It of course remains to be seen as to whether the current measures are going to encourage a more cooperative approach between landlords and tenants, or where on the flip side they're simply going to lead to mass litigation, disputing whether a tenant's been unable to pay its rent for COVID-19 reasons or otherwise, etc. So that really is a case of watching this space and seeing how the government react to as the 30th of June deadline looms. And again, we'll be glad to sort of assist as those develop. And if there is any intimation of action, again, please do contact us. We can look at what the current situation in respect of the regulations are and hopefully provide you some guidance to how best to deal with that. So that really is my roundup, David. I'll let you summarise your discussion and then we'll open the floor to questions.
Okay, thank you very much. Well, as I say, if you are a tenant who is in financial difficulty, you are certainly not alone. There will be many tenants who are unable to pay, or at least pay all of their rents, at least for a while. So don't feel that you're on your own. Do talk to your landlord, do talk to us if you need to. Some landlords, as I said earlier, will of course be keen to remove their tenants if they think you're awkward or if they want the property back for a different reason, but they are going to be in the very small minority. And frankly, most landlords will know they don't have a better option at the moment than to work with their tenants. So make sure you do work with them, be collaborative for the solution. And most importantly, if you do find a solution, document it properly. So thank you very much for joining us. Before we take questions, just to let you know, we will be sending out a recording to everyone that signed up for today's webinar tomorrow morning. So if you enjoyed it so much, you will be able to listen to us all over again. We'll also include a link to a very short feedback survey, and we'd really appreciate it if you could complete that so we can make sure our future webinars are helpful to you and to others. As I said at the start, this is one in a series of Wednesday webinars. Next week's session will cover COVID-19, are your terms of business adequate? And now we'll take questions. Thank you very much.
Thank you. The first question is for Emma. Question being, what if the landlord is adamant that the full rent is needed to be paid in advance, but you cannot afford it?
Okay, so I mean, it sounds like that if we've got to the point of asking that question, perhaps initial discussions with the landlord have been had. So on the presumption that the stage of negotiations has passed with the landlord, we're then in a position, I think, going back to my opening, is what can the landlord do? If a tenant cannot afford to pay and physically doesn't have the money, and the landlord will not perhaps accommodate any requests, a payment plan can't be reached, etc., then we look back to can the landlord do anything? The answer at the moment is yes, although it's very limited until the 30th of June. So unfortunately, it sounds like in that situation, it may well be a case of stalemate until the 30th of June. The answer is that if that fate or inability to pay is due to COVID-19, then the landlord can't do an awful lot at the moment, but that will offer little comfort for the position come the 1st of July, when, as things stand at present, their full range of enforcement options will be open. So I think whilst this moratorium is in place, the key thing to be doing is just pressing on with those negotiations. Even if they are fruitless, any commercial landlord will know that actually at the moment their options are limited, and it may be that they would rather have a limited payment scheme in place as opposed to simply having to wait until the 1st of July and then taking more drastic action, which will inevitably cost them money in legal fees, and could ultimately, if the tenant doesn't have the money, lead to a position where they're doing as they please but don't get their money back. So I think unfortunately it's just a really difficult position until the at the moment until the end of June, but it's a case of really trying to push those negotiations and seeing whether the government does introduce any further measures that offer temporary protection.
Thank you, Emma. I think this is another question for you, Emma. Are there any provisions which reduce the liability of an insurance policy to keep property occupied?
David may also wish to comment on that in terms of anything that's been introduced by the government, by legislation or otherwise, which would alter or amend an insurance policy. Not that I've seen, no. In terms of occupying the property generally, again, I'm relating back to a lease term that says the property must be operating, must be occupied, must be, I don't know, trading as, etc. There are provisions in place in specific leases. If there is a keep open provision, there may equally be an illegality clause, which necessitates a tenant to act in compliance with any government restrictions or laws. So if that were in relation, which I appreciate it may not be, to a keep open clause within the lease, there may be something within the lease to assist. But in terms of anything which alters an insurance policy, no, I'm not aware of any measures. That said, insurers will be well aware of the current pandemic. So again, it goes back to trying to keep that open dialogue. Also check the terms of the insurance policy, because if there is anything in that policy about an illegality clause, which is essentially the policyholder in that instance must comply with the current regulations and laws, etc., then there has been recent discussion about that possibly, in fact, I would say probably, extending to situations where the government have introduced lockdowns, which means that a tenant perhaps cannot operate from the premises. So I hope that provides some initial guidance.
Okay, well, I'll just add into that, and I think Graham raised that question, but you will know that insurers charge different premiums for empty premises and for occupied premises, and so it is really important to make sure that A, you've told the landlord what the situation is, and B, that the landlord has told the insurers, because you don't want anything happening that would mean that the insurance might be voided, and you don't want anything happening that might increase the insurance premium that's payable. So as we've said a number of times, it's really important to be talking to the landlord, and of course if you're the tenant and the landlord's insuring, it's a bit difficult because you're going through the landlord to get to the insurers, and that's always something that can cause tensions, and I think it's really important that you make sure that the landlord is communicating with the insurers, letting them know whether the property is vacant temporarily, making it sure certainly that it's secure, so that there isn't an adverse impact on either the insurance policy or the premiums that are payable.
Thank you, Emma and David. That's actually all the questions that we have. So that will conclude.
Well, on the assumption that we haven't actually sent everyone to sleep, thank you very much for joining us. I hope you found that useful. Emma and I have certainly enjoyed delivering this webinar in the Burkitt Long Wednesday webinar series, and hopefully you will join us for future webinars on other Wednesdays. Thank you very much and goodbye.